as we approach retirement age, for many of us, our two largest assets are going to be the value of the equity in our homes and the value of our retirement accounts. And at least here in the United States, the two most common type of retirement accounts are 401ks and IRAs. And not only is it important what types of investment options you have and what the underlying costs are, but I think a really important factor to think about is creditor protection. Is an IRA and a 401k, are those treated the same, or are those treated differently? Unlike a lot of things in financial advising, unlike a lot of things in economics where the answer is, it depends, we actually have specific numbers. These cases, this argument, these questions have been taken all the way up to the Supreme Court, and now we have specific guidance on what type of protection that you do have. So first, let's talk about a 401k. A 401k is an employer-sponsored plan. And because it's an employer-sponsored plan, it's regulated by the Department of Labor. And then a traditional IRA is an account that the owner establishes without your employer's involvement. Now, the Department of Labor has very strict regulations and very clear guidance on creditor protection. And essentially, you get a lot of creditor protection in a 401k. So I've been a family financial advisor now for over 20 years. For many years, the default answer that people would give me is, I'm going to leave my money in my 401k because I've heard that it has creditor protection. If, God forbid, I were to ever have to file for bankruptcy, because the 401k is regulated by the Department of Labor, I have greater creditor protections. And for many years, it was it was not perfectly clear what type of creditor protections you got in an IRA. And then in 2005, a case went all the way to the Supreme Court. It was Rousey v. Jackaway. And the Rouseys, unfortunately, were declaring bankruptcy. They had about $50,000 in an IRA. And when they declared bankruptcy in Arkansas, they said, hey, this IRA is creditor protected. And there's all kind of legalese here. I'm not going to get into that because I just think it's too much details. But I do think some of the facts are important. So again, this was in an IRA, and importantly, it used to be in a 401k, but they worked for Northrop. And Northrop forced them, and when employees left, they said, you cannot keep your money in our 401k, so they put that money into an IRA. Again, it went all the way to the Supreme Court. The lower courts said, you know what, this money is not protected. Went all the way to the Supreme Court, and believe it or not, it was a unanimous decision that said, in their case, in the Rousey's case now, they only had $50,000, right? Now, this was 2005, so almost 20 years ago. But it wasn't millions and millions of dollars. And the Supreme Court agreed with the Rouseys and said, this is protected for a variety of reasons that's outside of the scope of this video. But I do want the Supreme Court, actually, believe it or not, has a blog, and they had a blog back in 2005. And what the Supreme Court said here is, in conclusion, the justice, the lead justice, which was Thomas, they focused on the requirements that it was similar to other contracts, other types of payments that were protected under federal bankruptcy law. Now, this is important because could a creditor sue you and you not declare bankruptcy? So the Supreme Court just ruled on if you declare bankruptcy. So this is not a blanket statement. But they said, yes, you do have protection. And then later, 2005, the Bankruptcy Abuse Prevention and Consumer Protection Act, the BAP-CPA of 2005, what they said is there's a specific dollar amount. And in the current 3-year period, which began on April 1st, 2022, both traditional and Roth IRAs are protected to a total dollar amount of $1,512,350. So there's a specific number, and that is per person. And this limited protection applies to the sum of all the traditional and Roth IRA accounts held by a given individual, and it's not to each account in isolation. So it's an aggregate per person. It does get adjusted for inflation every 3 years. Again, that was put in place by the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. So every 3 years that gets updated. So in April of 2025, it'll be updated for inflation. Now, and I have to really stress this, I am not an attorney. I am a financial advisor, but I'm not your financial advisor. I don't know your specific situation. So it's not financial advice, and it certainly is not legal advice. My goal in this video is to put some things on your radar screen. And then I've got a conclusion, what I think you ought to do. So stay to the end because the conclusion is super important. Okay, what about SEP IRAs and simple IRAs, which are often used by self-employed people? And instead of going through the complications and the costs of setting up a 401k, the ruling says that IRAs are fully protected in case of bankruptcy, just like a 401k. So the 401k is generally believed to have no limit on the protection in bankruptcy, creditor protections. And the SEP IRAs and the simple IRAs are similar. Now, there's also a special protection for rollover IRAs that come from this Bankruptcy Protection Act, the BAP-CPA. A rollover IRA is a traditional or Roth IRA account that was originally funded from a qualified retirement plan, like a 401k. And under BAP-CPA, a properly executed rollover IRA originating from a qualified retirement plan is fully shielded from creditors in bankruptcy. Now, this is from a website called Investopedia. Now, these things get complicated because while I said an IRA is protected, you know what's not protected is an inherited IRA. Inherited IRAs are not protected from creditors. So if you inherit an IRA, let's say from your mother, it's not protected. And there was a separate Supreme Court case that went forth in 2014. And that was the case, the person's name, if you want to look up the case, is Rameker, R-A-M-E-K-E-R. And in this case, a woman had inherited a $300,000 IRA from her mother. Unfortunately, they went through bankruptcy. And in that case, it was Supreme Court decided, no, in that case, it's not protected for a variety of reasons. So, you know, I said at the end I was going to share what I think you should do. And I think you can see the details matter, right? If all you took from a video on the internet, on YouTube was, you know, well, IRAs up to that $1.5 million that Azul mentioned, they're protected. Well, it's not that simple, right? Because an inherited IRA is not. So what do I think you should do? I really think you should talk to an attorney. Make sure you understand your specific situation. You have worked hard for your money. You deserve to know how to best protect it, how to best invest it, how to best protect your assets is a job best done for an attorney. How to best grow it, how to best plan for your retirement, I would argue is a job best done by a professional, a fieldly financial advisor that has your best interest in mind. Can you do it yourself? You can, but what if you miss something, right? This is your life's savings and you want to spend that money wisely. So I also want you to watch this video up here that talks about 5 reasons to consider retiring as soon as you can. I'll see you in there. Bye-bye.